Hello and welcome to today's program, War, Peace, War, and the Legal and Practical Limits on Armed Conflict in Space. This program is brought to you by the ABA Standing Committee on Armed Forces Law, or SCAFL, and the ABA Young Lawyers Division Government, Military, and Public Sector Lawyers Committee. I am Joe Allers, the YLD liaison to SCAFL, and I will be serving as the moderator today. Space. For everything we know, or think we know, there are galaxies, maybe even other life forms that humans on Earth may not discover for thousands of years, if ever. We romanticize space, we make movies about the people who have the privilege, for even just a few moments, of seeing the Earth with a view like no other. It is, to get not too cliche, the final frontier. It is also quite possibly the next battlefield. 50 years ago, the foundation of how we as a human race would explore what's beyond the stars took shape through something called the Outer Space Treaty, a foundation of law that sought to prohibit weapons of mass destruction in space and reserving the moon and other bodies for peaceful purposes. But we're constantly reminded that that may not be the case. Just a few days ago, General John Hyten, the commander of U.S. Strategic Command, noted that both China and Russia have been developing assets capable of using lasers and other jamming functions from space, both potential acts of aggression that follow years of question about what exactly is happening thousands of miles above our head. To get us started today, let's turn to some real experts. Joining us today are Dr. Brian Whedon, the Director, Program Planning at Secure World Foundation, Mr. Michael Hoverson, the Chief, Space, Cyber, International, and Operations Law at Headquarters, Air Force's Space Command, and Major Ross Brown, the Chief, Space, International, and Operations Law at Headquarters, 14th Air Force. Before we get started, several of today's speakers are employed by the United States government, and for our audience, please note that their views expressed in this webinar are their own views and not necessarily the views of their respective military service, the Department of Defense, or the U.S. government. To start us off today, let me introduce Dr. Brian Whedon from the Secure World Foundation. Dr. Whedon has 17 years of professional experience in space operations and policy and has a variety of roles at the Foundation, including strategic planning, research, and organizing national and international workshops on space security and stability. Prior to joining the Foundation, he spent 9 years as an Air Force space and intercontinental ballistic missile officer, and he earned his PhD in public policy and public administration from George Washington University in the field of science and technology policy. Dr. Whedon, the floor is yours.
Thank you very much, Joe. Good afternoon, everybody. I thought we would open up today's webinar with a few slides that focus on sort of the reality of what we're talking about when we talk about conflict in space. And I think it's important because most people do not have a personal hands-on experience with space. Their experience with space come through television and Hollywood movies and reading science fiction books. And in all those cases, in almost all those cases, the depictions of warfare and combat in space are frankly not real. They're fictional. They often take extreme liberties or just outright ignorance of the laws of physics and orbital mechanics, conservation of energy, and all sorts of other things in order to make it much more dramatic and exciting. So what I hope to do over the next 10 minutes or so is to talk about what the real version of conflict and warfare in space is probably going to look like as opposed to the Hollywood version. And I think it's going to be just, in some ways, just as interesting because it's going to have a lot of real-world impacts. I will note that there is one science fiction series out there that does get space warfare pretty right, and that would be the Expanse book series, which is excellent. So we can go to the next slide, please. First, why is this becoming an increasing topic? Well, historically, space was mainly used for what are known as strategic missions for national security. By that, we mean space was used for intelligence, to figure out what other countries were doing. It was used to verify arms control treaties, and it was used to provide potential warning of nuclear war. And all of those were extremely important functions, and in particular the linkage to nuclear war, that acted as sort of a deterrent towards attacks on space capabilities, because there was a concern that you attack those space capabilities, that could be a signal or lead to nuclear warfare. Today the environment is much different. Space is still used for those strategic functions, but is also used for operational and tactical functions at basically all aspects of national security and military power. We still use space for strategic intelligence, but we also use it for intelligence and reconnaissance that support all the way down to the warfighter deployed in the field. Space is used for all sorts of communications, it's used for timing and navigation, and it's used to provide attack warning and characterization of potential threats. It's hard to think of any military operations the United States conducts today that don't involve space in some manner. And so as a result, counterspace, which is coming up with ways to deny, degrade, or destroy space capabilities, is becoming a part of conventional warfare, because space itself is part of conventional warfare. So an example on the next slide involves RPV operations. That's remotely piloted vehicles, what are commonly known as drones or UAVs. This is just one example of the role that space plays. So most RPVs, and at any given time, the United States operates a few dozen of them in the air, scattered around the world. Nearly all of them are flown remotely by operators located in the continental United States. And those command and control signals move over communication satellites to get from the United States to where the RPVs are locating around the world. The second major space role in RPVs is through guidance and navigation. U.S. military satellite constellation known as GPS is a constellation of about 30 satellites orbiting about 12,000 miles above the Earth, providing signals that are used to do precise geolocation. RPVs use those signals to navigate and know where they are, and if they fire a weapon, that weapon is guided largely through using GPS signals. And then the third is the satellite shown on the far right, which is an imagery satellite, in this case a commercial imagery satellite, and those satellites are used to not only provide intelligence about where we may want to put RPVs, but also to do follow-up after attacks of damage assessment and provide things such as signals intelligence that RPV itself might not be able to provide. Next slide, please. So as we sort of hinted at with that diagram, when we talk about counter space, we talk about the capabilities that can go after one of three different segments of a space capability. That would be the ground segment, so where a satellite is commanded and controlled from, the space segment, which would be the satellite itself, or satellites in some cases, and then there's also the user segment, which is the people that are using the data or the capabilities or the services being provided by the space capability, and that's usually flowing over some sort of an internet connection or a network connection. And then the fourth element here are the green arrows pointing from the satellite dish up to the satellite, and that's the link. If a satellite has to communicate with the ground in order to get instructions, in order to be able to relay data back, and so interfering with those links is yet another way to go after a space capability. Next slide, please. Counterspace or attacks against satellites, you can think of them coming in kind of two big flavors. One would be electronic warfare attacks, which can also include cyber attacks, and those would be attacks against those links. And then another big category would be kinetic attacks, which we'll talk about in a second. So for electronic warfare attack, if you build the slide out one phase, you can see that normal operations are you have the dish on the left that is sending signals up to a satellite, and that satellite is then relaying those signals back down to one, or in some cases, many different users on the ground. In this case, it's a communication satellite, so they're relaying signals to troops in theater, to RPVs and to ships at sea all at the same time. So if you build forward one more, you'll see an example of what's known as uplink jamming. So in this case, there's a second signal, the red signal, that is also being directed at the satellite. And the purpose of that second signal is to interfere with the real signal. And this has the effect, if it's done properly, of basically scrambling or interfering with the signals being received by just about everyone that is in the satellite's footprint. Build more twice, please. So the second example is known as downlink jamming. In this case, somebody has put a jammer near the ship. And this jammer is creating interference with the ship's ability to receive those signals. That could have significant implications for that particular ship, but is not necessarily going to have an impact on everyone else. It's generally limited to a localized area. So an example of this might be the GPS jammers that you can find on the internet and other places that you can put in a car, and that would create sort of a bubble around that car of probably 100 or a few hundred yards that would jam GPS signals within that bubble, but outside of that, everything would probably work out well. So these are examples of electronic warfare attacks on satellites. Next slide, please. So this is going to be a short video describing or showing an example of a kinetic attack. Kinetic attack means you're actually going after physical destruction of something, and in this case, the satellite itself. This is an animation showing a real-life event, which was in 2008 when the United States Navy launched a ballistic missile from a ship that was used to destroy a satellite in very low Earth orbit. That satellite was determined to pose a threat because it had a large amount of frozen fuel on board, and if it re-entered, it could pose a hazard to people on the ground. So the decision was made to launch the missile to intercept the satellite and destroy it to then prevent that risk. So go ahead and play the video, please. The video is going to start off with kind of a simulation of the missile being launched from the ship, and now you see the trajectory of the two objects. They collided at a speed in excess of 7 kilometers a second. And what happens then is the satellite that was up there in space basically keeps going through its orbit, but now is thousands and thousands of pieces. And those pieces keep going around the Earth, and some of them, as you can see by the red, are re-entering, but the rest are kind of continuing in orbit around the Earth. Thankfully, in this case, the satellite was already at extremely low orbit, around 220 kilometers, and so all of the resulting debris from this collision re-entered within about 18 months. But the same sort of kinetic attack against a satellite in a much higher orbit would result in that hundreds or thousands of pieces of debris being up there for many years, possibly even decades. Next slide, please. So just to close, in comparison, there's kind of two big ways to go after satellites, and that's a non-kinetic, such as jamming, interference, maybe even cyber attacks, and then there's kinetic attacks. What we're seeing is that non-kinetic attacks are actually occurring. There's lots of examples of jamming out there because they're much cheaper, easier to pull off. They're harder to verify. Well, they're cheaper, easier to pull off, but in contrast, it can be harder to verify they've worked. But on the plus side, they also have no long-term negative impact on the space environment. In contrast, a kinetic attack, it can be more expensive to pull off. You have to have, in this case, sophisticated ballistic missile, good targeting, and it's much easier to verify that it's worked because you could actually destroy the actual satellite. But a significant negative is that they can create long-lived orbital debris, which then can have impact for everyone. So that was it for my section, and that was meant to be, that's a kind of a primer on the sort of things we're talking about in this notion of conflict in space.
Thank you, Dr. Whedon. Just a reminder to attendees, if you do have any questions, please type them in the box and we will address them at the end of the webinar. Our next speaker is Mr. Michael Hoverston, the Chief of Space, Cyber, International, and Operations Law at Headquarters, Air Force Space Command. Mr. Hoverson is responsible for providing legal advice to military commanders and government officials on all space, cyberspace, international, and operations law issues affecting Air Force Space Command. A retired U.S. Air Force judge advocate, Mr. Hoverson has more than 24 years legal experience in a myriad of disciplines to include over 17 years experience advising top-level government officials in the Air Force and Office of the Secretary of Defense on military space operations, international space law, international law on the use of force, and the law of armed conflict. In addition to Air Force Space Command, Mr. Hoverson has held positions at the Office of the Secretary of Defense, Headquarters U.S. Air Force, and other U.S. Air Force organizations. Mr. Hoverson, the floor is yours.
Good afternoon, everyone. Let me begin by thanking ABA Scaffold and the Young Lawyers Division for inviting me to participate this afternoon. It's my pleasure to do so. So you've heard from Dr. Whedon some of the realities of military operations in space and some specific types of attacks that might occur on various space segments. What I hope to do over the next 10 minutes is to give you a very broad overview of a body of international law that applies and would impact those military operations, specifically international space law. Slide, please. So there are 5 treaties that encompass the bulk of international space law. The first and probably most important is the 1967 Outer Space Treaty. It's kind of the grandfather of space law, if you will, and it's there that we're going to focus on today, some of the specific provisions within that treaty. The other 4 treaties listed there are an expansion and provide more detail on some of the provisions in the Outer Space Treaty. I'll go over them very briefly. The Rescue and Return Agreement has to do with the rescue and assistance to astronauts and the return of space objects to the state of origin that might deorbit and return to space. The Liability Convention establishes a liability regime for damage caused by space objects, either terrestrially here on Earth or in outer space. The Registration Convention creates requirements to create both national and international registries where space objects once launched into space must be registered. It was an effort to create some kind of transparency in space operations between, at that time, the 2 national powers, the United States and the Soviet Union. It also serves as a rudimentary form of space situational awareness, that is, having an idea what is up there. The last treaty there listed, you'll see, is kind of in light gray in the Moon Agreement. And the reason it's in light gray is that while the 4 other treaties are widely accepted and have many parties to them, the Moon Agreement is not. It only currently has 14 parties. It is in effect, but none of the parties to that agreement are national space powers. There's a lot of controversy over the Moon Agreement regarding resource exploitation and sharing, and so it wasn't widely accepted. Slide, please. So as I said, we're going to focus on some of the principles in the Outer Space Treaty. The first is what is referred to as the Freedom Principle. And what that principle says is that outer space is free for exploration and use by all states. The reason that that's important from a military perspective is twofold. One, with some limitations that we'll discuss later, outer space may freely be used for military purposes. The second is that the legal regime in outer space is completely different than that in airspace. And that being that national sovereignty exists in airspace and the airspace over national territories. So obviously, military aircraft are prohibited from flying in sovereign airspace unless granted permission by the sovereign. In outer space, on the other hand, because it is free for exploration and use, states are free to overfly the territories if in outer space and conduct operations that Dr. Whedon mentioned, in particular, intelligence, surveillance, and reconnaissance. Slide, please. The second key principle that I'd like to discuss briefly is what is known as the Non-Appropriation Principle. And the Outer Space Treaty states that outer space, the moon, other celestial bodies, stars, asteroids, any type of celestial body is not subject to appropriation in any way whatsoever. This is the reason that when Neil Armstrong landed on the moon and planted the U.S. flag, he did not claim the moon on behalf of the United States. Doing so would have been unlawful. It's important to understand that not only celestial bodies are not subject to appropriation, but neither is any type of open or free space, if you will. Orbits are not subject to national appropriation. Orbital slots are not subject to national appropriation. Slide, please. The third key principle that I'd like to address is that international law applies in outer space. Article 3 of the Outer Space Treaty specifically says that the use and exploration of outer space must be conducted in accordance with international law, including the Charter of the United Nations. Slide, please. So why is that important from a military perspective or regarding military operations? The main reason is that any operations that are conducted in outer space must comply with the law that's applicable in all other domains, air, land, and sea. So principles of customary international law and treaties are applicable in outer space. The law of armed conflict is applicable in outer space. Any UN Security Council resolutions that might be relevant are applicable in outer space. And the rules on the use of force in the UN Charter are applicable, as is the inherent right of self-defense. So if a state were attacked in ways that Dr. Whedon previously discussed, if those attacks amounted to an armed attack under the law of the UN Charter, the right to use force and self-defense to defend those assets applies. Slide, please. All right. Many of you might have heard the concept that outer space must be used for peaceful purposes. And that's true. I would agree that outer space must be used for peaceful purposes. But what you might find interesting is the Outer Space Treaty does not specifically state that outer space must be used for peaceful purposes. The word peaceful and the phrase peaceful purposes is used in the treaty in a few locations, but in nowhere does it specifically state that outer space must be used for peaceful purposes. Now, one could argue that under the UN Charter, which outlawed aggression in international relations generally, that all state activity must be for peaceful purposes. The question then is, how do you define peaceful purposes? And early on, there were two interpretations of peaceful purposes, at least as it applied in outer space. The first was that it means absolutely no military use. That's the minority view, extreme minority view at this point. The reality is that multiple states around the world use outer space for military purposes. The majority view is that peaceful purposes, from a legal perspective, means that military use is permissible provided that it's non-aggressive and is consistent with international law and the UN Charter. Meaning that military operations may take place provided that they're defensive in nature. And really, under the UN Charter, all military operations must be defensive in nature. One caveat to that is the Outer Space Treaty does specifically state that the moon and other celestial bodies must be used exclusively for peaceful purposes. That language is akin to language you'll see in the Antarctic Treaty, and it means no military use, no military fortifications, no military use whatsoever. So military fortifications on the moon, on other planets, impermissible, but military use in orbits and in free space, if you will, permissible, provided they're non-aggressive and consistent with international law. Slide, please. One quick note on the terms militarization and weaponization of space. This, I must say, is my personal view. Different states use these terms differently, and so you have to be very careful when using these words. But from my perspective, militarization of space equals military use. So military or outer space has been militarized for decades because it's been used for military purposes almost since the inception of man traveling to the great frontier. Weaponization of space, however, is akin to the placement of weapons in outer space. And to date, as far as we know, that has not yet happened. And I'd like to discuss weaponization of space in a little bit more detail. Slide, please. So there's a common misconception out there that weapons of all kinds are illegal in outer space, and that is not the case. The Outer Space Treaty has a very specific prohibition on nuclear weapons and other weapons of mass destruction, chemical weapons, biological weapons, radiological weapons. But those are the only types of weapons prohibited in outer space, and they're prohibited in orbit, on celestial bodies, in any manner whatsoever. However, other types of weapons, electronic warfare weapons, lasers, other directed energy weapons, and including kinetic weapons, may lawfully be placed in orbit around the Earth. It just hasn't happened as from a practical perspective to date. There have been some recent efforts, and by recent I mean over the last 8 or 9 years, to prohibit all types of weapons in outer space. Russia and China have been the primary proponents of the PPWT treaty, or the Prohibition on the Placement of Weapons treaty. And interestingly, the U.S. has been the main opponent to that treaty, primarily because there's difficulties in defining exactly what a weapon is. Theoretically, any satellite that's capable of maneuver could be used as a weapon, and most are today. And secondly, it would be an arms control treaty that would be unverifiable. Because of the nature of the space domain, verifying compliance with the treaty would be very difficult. And while I'm not an arms control expert, my understanding is that arms control agreements have little effect if they can't be properly verified. Slide, please. Now we'll move to a different topic, and that is of space debris. As Dr. Whedon said, kinetic attacks in space, depending on where and how they occur, could possibly create large amounts of debris. Debris is a problem, a growing problem, even without any kind of military attack in space. However, there is absolutely no international law specifically governing or prohibiting space debris. In fact, during normal space launch operations, a good amount of debris is generated with every launch. It's just the nature of the business. Now, there are efforts to mitigate and minimize debris. The Interagency Debris Coordination Committee is addressing the issue, and there are some non-legally binding debris mitigation standards out there. The UN Committee on the Peaceful Uses of Outer Space has a set of debris mitigation standards that it encourages all spacefaring nations to adhere to. And U.S. national policy specifically requires that measures be taken to mitigate orbital debris. And the United States has a set of formal debris mitigation standards and practices that U.S. spacefaring, U.S. entities have to adhere to. They're not law, but they are mitigation standards that are required to be followed. So with that, I will close, and I look forward to your questions. Thank you.
Thank you, Mr. Hoverston. And last but certainly not least, Major Ross Brown, the Chief of Space, International, and Operations Law at Headquarters, 14th Air Force. Major Brown is a judge advocate in the United States Air Force, and in his capacity, he advises the 14th Air Force Commander and the Joint Space Operations Center Director on legal issues related to the planning and execution of Department of Defense space operations and exercises. Major Brown was formerly an Air Force-sponsored LLM student at McGill University's Institute of Air and Space Law, where his research focused on state responses to internationally wrongful acts taken against national security satellites. Major Brown has been an Air Force judge advocate since 2008. Take us away, Major Brown.
Okay, thank you, Joe. And you've done such a good job in your initial introduction that I don't need to introduce myself very much. I also don't even need to make the disclaimer. So thank you for that. I guess one thing that I'll add regarding the disclaimer briefly is that in my current job, I work in the center. One of the things I do is I work in the center that helps the four-star general who's in charge of all DoD space assets kind of execute command and control over the satellites. However, all the research that I've done, opinions I've reached, et cetera, were done before I came in my current position. And so they certainly should not be taken to reflect my current position or the position of those that I work with. So the thing that I want to do today, in this time that we have, is look at a few aspects of conflict in space, how international law applies to conflict in space, and discuss some of the problems that exist with that, and also discuss a proposed resolution that I have. The basic scenario that we're going to be using to look at this, to examine this, is a national security satellite of one state that is suffering interference. This interference is coming from another state. However, this interference that is being suffered does not constitute an armed attack. When I refer to a national security satellite, I'm referring basically to what Dr. Whedon referred to regarding, say, navigation satellites, communication satellites, reconnaissance satellites that are operated by a state military or state intelligence agency. And then interference can be any number of things. What I am referring to is not necessarily it's not going to be kinetic interference, because I will assume for this discussion here, the kinetic interference would likely constitute an armed attack, and what we're looking at is interference below an armed attack. But we are thinking about things such as a cyber attack, such as jamming or other signals interference, and also directed energy weapons, perhaps, such as a laser being used to blind or to dazzle a sensor on a reconnaissance satellite, that sort of thing. So with that description of what the scenarios that we're looking at, let's go on to the next slide, please. So a couple of items of black or gray letter law of space conflict is that if you are, and this has already been touched on somewhat, if you face an armed attack in space or anywhere, you're able to respond in self-defense. If the interference or the action that you're suffering does not rise to the level of an armed attack, then in space, at least, the most applicable response is going to be a countermeasure. We'll discuss a little bit about what each of those are. I will say that there is certainly a question as to what constitutes an armed attack in space, what constitutes an armed attack in cyber as well. There is really a parallel question. But for now, we'll say it is an attack per likely kinetic, not necessarily kinetic, and by kinetic I mean things blowing up or exploding or otherwise being damaged, whose scale and effects are significant enough that the international community will say, okay, we're going to consider that an armed attack. That's a bit of a question. There's also a question as to whether a use of force and an armed attack are the same thing. In general, the international community's majority opinion is that they're not the same thing. The United States adopts a minority position, though, that if you do engage in use of force, that is also an armed attack. So what we're talking about here, though, is something below an armed attack. We're talking about a wrongful act that does not constitute an armed attack. So in those instances, the most applicable response would generally be a countermeasure. A countermeasure is an act that would otherwise be unlawful, but that in this instance be unlawful because it violates an obligation owed toward another state. But in this state is deemed okay because it is meant to counter and to stop a precipitating wrongful act taken against the victim state. Countermeasures have some restrictions. One of the restrictions is they must be proportional, and this is an injury-centric proportionality, which we'll discuss a little bit more. Also, countermeasures must not be forceful. You can't use force in countermeasures. They must be constrained in time. You can't start a countermeasure before a wrongful act is taken against you, and after the wrongful act has ceased, then you must stop the countermeasure. Also, there is a somewhat mushy requirement that they must be reversible. I say mushy because, one, this requirement is generally seen as being as much as possible or to the extent possible, and also there's a significant amount of commentary and discussion that focuses on the reversibility applying not necessarily to the effects, as in can we reverse whatever damage you've inflicted, but does it make it so that the countries can get along on good terms again. So the reversibility requirement is a little bit mushy, but it exists nonetheless, and those are some of the main requirements that I want to highlight for purposes of our discussion here. If we go to the next slide, please. So, as we just discussed, that's the traditional way of looking at responses to hostile actions, to internationally wrongful acts, and it works well in it works fairly well in traditional military type activities. And things like countermeasures can work especially well when you're looking at things like trade agreements or violations of treaties, or something where your responses are going to be more on a statesmanship type level, deciding how to respond from one political body to another in response to something that was wrongful that was done against you. However, when we're looking in space, we have the same basic structure of how we're able to respond to wrongful activities, but there are some problems that exist in space and that are accentuated in space that don't necessarily exist or don't exist to the same degree elsewhere. One of the problems that I'll point out is this time constraint restriction. So as I mentioned, countermeasures must be constrained in time, can't start before or after the precipitating wrongful act is taking place. This makes sense because the point of a countermeasure is not to punish someone. It's not to deter them from doing this wrongful act in the future. Really, what it is meant to do is meant to make a wrongful act that's happening stop. So if a satellite is being jammed, the countermeasure would be determined not to make it such that the precipitating state wishes they had never ever jammed this satellite or vows never to do it again, vows internally never to do it again, but to just make that jamming instance stop. And so once the jamming instance has stopped, then the countermeasure is supposed to stop. The problem is that in space, with the technological nature of it, much of this interference can be turned on and off with a flip of a switch. Jamming, as has been discussed, can happen easily, or it can start easily, it can stop easily. Dazzling or blinding of sensors on a satellite can be initiated or stopped easily. There's a question of when one precipitating state is doing this on and off, is this act continuing? Has it stopped? When must our countermeasures stop? When are we allowed to keep going? I will point out, and this is something that makes this time constraints issue a little bit easier to handle, is that most discussion of countermeasures says that if reparations are due, then the countermeasure may continue until reparations are granted, until the situation is resolved completely and any sort of damages are rectified, etc. And so even though that can be a bit mushy, what it does mean is that the time constraint, law constraint, is not necessarily as strict as one might think. However, something that is perhaps more problematic is the injury-centric proportionality. This means that the response must be proportional not to the objective, when the objective being to make this jamming or this other interference stop, but to the injury that's being suffered. That makes it a somewhat difficult assessment to quantify what your injury is. You look just at monetary damages, if there are any sort of damages, say to your satellite. Do you look at strategic harm suffered? If this is a reconnaissance satellite and you're unable to gather information, how are you measuring your injury? Also, even assuming you are able to measure your injury, that doesn't mean that your response is going to be able to be strong enough to make that interference stop if it becomes evident that your response is disproportionate to the injury that you're suffering. This is as opposed to in self-defense, where the proportionality must be proportionate to the objective that you have. However, the objective in countermeasures is not what's focused on. It's the injury when you're looking at proportionality. This is somewhat ironic, since the point of a countermeasure is to make this stop, make the action stop. But that's how that is. In addition to that, sorry, I logged out briefly. Here we go. In addition to that, there has been identified a sort of use of force gap. The majority opinion is that it is possible to use force and not yet have that be an armed attack. Under countermeasures, you're not allowed to use force to respond to force. So what that means is that force might be used against you, but you are not able to respond in kind to make this this interference stop. And so that creates a sort of sweet spot for precipitating states where they may do something to you and know that you cannot respond with a similar level of force. I'll point out that the majority position is that there exists a gap. There's a minority position held by the U.S. Among a few others that anytime you use force, that is an armed attack. Also, there is a minority position on the ICJ, the International Court of Justice, that even though there is this gap, that force is used against you, you can use force to respond to that as long as you stay below an armed attack. However, those are both minority positions. If you can go to the next slide, please. So the question is, where do we go from here? We can keep on keeping on, as I say, and work under this approach of armed attack and self-defense, or something other than armed attack and countermeasures. Or what I've proposed is a sort of hybrid of the two, born out of the fact that this space is strategically important, that it has technological unique areas to it. And this is what I've called defensive counteractions. Basically, calls for objective-centric proportionality, so allowing the state to focus on their objective, which is making this jamming stop. It allows force only in response to force, but it does allow force in response to force. There are looser time constraints, such that if you believe that the jamming will continue shortly, or that it is perhaps ongoing and just intermittent and will resume shortly, or if the other state will not assure you that they are going to discontinue their activity, then you can continue with that. This includes also a possible long-term disabling of the adverse asset. So disabling long-term through whatever means, not necessarily kinetic, but through other means, say the entity or the asset that is jamming you, that is lasering you, that sort of thing. Also, some restrictions regarding immediacy. It has to happen. This defensive counteraction has to happen shortly after, kind of ingrained in time with the harm that's suffered. You have to target the asset that is targeting you, and then also some third-party protections: no creation of space debris, and then also no harming other nations, such as by doing an EMP, an electromagnetic pulse, that would harm other satellites as well. My time is about up, so I will wrap it up. But that is my proposal to the problem that we're facing. If we could just go to the next slide. And so that is my proposal. And bottom line, what I guess I hope you take away from this, from what I've said briefly here, is the space is an intensely interesting area to examine and to practice international law. There are so many issues that are being raised, and there are some problems that are being discovered, that are being raised as well. And I hope that we can solve them, and that we can direct and contain state responses to activities taken against them, and to keep it all within the legal regime, so to speak. Thank you.
Thank you, Major Brown, and thank you to all of our speakers. We are now going to move into questions. We have a number of great questions. I'm going to read and then combine some of them to try and get through them all. We're going to start with a question for Dr. Whedon. One of our guests asked, how common or uncommon are cyber attacks against military communication satellites or against commercial satellites used by the military? Are commercial vendors obligated to report such instances of interference, jamming, or cyber intrusion?
Well, that's a really good question, and that's a question that I myself share. What I can say is that the public data on cyber attacks against any satellites, military, non-military, is extremely scarce. Militaries, governments, space agencies, and commercial companies are pretty reluctant to talk publicly about cyber attacks, successful or unsuccessful, against their assets. We know that jamming occurs pretty regularly. There have been a couple public reports of cyber attacks against the command and control infrastructure for a NASA and a NOAA satellite. Not a whole lot of details, but public reporting from U.S. Congress saying that it has happened. So it's really hard to give a definitive answer. I would say, if you think about it in the same context as kind of computers and IT equipment, if you had a computer from 15, 20 years ago and you threw it on the internet, it probably does not have very good defenses against modern cyber attacks. If then talk about the space world, where you have satellites and ground control infrastructure that could easily be 1, 2, 3 decades old, particularly when it comes to military government systems, I don't think it's a stretch to really wonder just how hardened they may be against modern sophisticated cyber attacks. But the real answer is the moment we don't have any good data on that.
And any comment on whether commercial satellites are required to report in any sense whether they've been the victim of some type of attack?
I know that the DoD recently implemented new cybersecurity requirements for all of its contractors that require breach notifications. So my guess is that they probably would be.
Major Brown and Mr. Hoverston, of course, understanding you may not be able to share all information with us. Anything to add?
This is Mike. I think from a general legal perspective, I'm not aware of any requirement to report. There might be contractual obligations, as Dr. Whedon was referring to. And from a proprietary standpoint, from a commercial standpoint, there may be many reasons they don't want to report. They don't want vulnerabilities or weaknesses known. It can hurt their business case, and it might invite additional attack.
Okay. We'll move on to the next question, and we're going to start with Major Brown. Major Brown, one of our users asks, considering this is happening in space, how do we know what's causing the interference?
That's a good question, and if I had more time, I would have discussed attribution as well. As a legal discussion, then we're just having to kind of assume attribution here, that we know where this is coming from, and that we're able to attribute it to a state actor as opposed to a non-state actor. So attribution is certainly an issue. Sometimes it can be more difficult than other times. It depends on what sort of interference you're facing with, say, with a downlink jamming of a GPS signal, for instance, because that's a fairly weak. It's a weak signal, and so it's easy to jam. You can tell at least where it's coming from. It's not necessarily who's doing it. You can tell at least where it's coming from. With other things such as lasing, so a laser is blinding or dazzling reconnaissance satellite, you can figure out, maybe not on the first swipe around, first orbit around, but you can eventually figure out where it's coming from, and that is the type of thing where it would be, you can figure out in general where it's coming from geographically, and that's the type of thing that would be much more difficult for just a private party to do on their own, and so it becomes easier to attribute that to the actual state. However, attribution certainly is an issue that would need to be considered, and before a defensive counteraction were taken, for instance, or other forms of countermeasures, depending on how you're doing it, then you would want to be able to attribute it to a state.
This is Brian. I can give a little bit more about the geolocation problem. If, for example, it's uplink jamming against a geostationary satellite, so that's in the case of an interfering signal is being directed at the satellite itself with the hope that it'll be rebroadcast and interfere with the signals coming down to end users. In almost every case, that signal being broadcast, the jamming signal, the interfering signal, is going to spill over onto nearby satellites next to the target in the geostationary belt. And so if you can actually talk to those other satellite operators, and you can get them to give you kind of the angle of where that's coming from on their satellite, you can then triangulate where on the ground that signal is coming from. Oftentimes that may not be, the triangulation can be difficult to get down very precisely, but that can often give you a general area or a country of kind of where the signal's coming from. But doing further attribution from there as to who exactly is doing it and why, that could be extremely difficult.
And let me tack a question on right there that one of our users asked. That's a perfect segue in. We're talking about these some of these non-kinetic attacks, more specifically cyber-type attacks, and all of our presenters talked about state actors. Are there realistic threats from non-state actors? So we talked about attribution. You know, how likely is it that anything that we've talked about today is going to come from anything less than a fairly organized state actor?
So this is Brian. I guess I'll start. I think there's definitely reason to be concerned, particularly for the non-kinetic attacks. You know, back in the 1980s, there was the famous case of Captain Midnight, who successfully jammed HBO satellite signal for a brief period of time. And there's been other cases of that have been going on ever since. It's well known that GPS jamming, at least at the localized level, is well within the range of individuals. There was a court case, I think it was in New Jersey, where they were having intermittent interference with GPS at the Newark airport, and it turns out it was being caused by a truck driver who had a GPS jammer installed, and every time they drove by the airport, they would interfere with the GPS landing systems. And there's also increased activity among kind of the hacker community looking at satellite systems, particularly some of the commercial satellite services, and they're finding some challenges there. So at least on the non-kinetic means, I think it's perfectly valid to be worried about non-state adversaries having the ability to engage in counterspace. When you're talking more about the kinetic attacks, now you're talking about either extremely high-powered lasers, you're talking about sophisticated ballistic missiles, you're talking about things that are generally outside the scope of most non-state actors.
And this is Ross, and I'll second what Dr. Whedon said. That is absolutely right, and I'll add just sort of as a gee whiz, and this kind of goes to the opposite end of the question, I suppose, and that is that if this interference is being sourced in space, if it is coming from space, let's say if jamming is coming from another satellite or something like that, even if, say, it were to be coming from a commercial satellite, which would be an odd scenario, but say that were to happen, the launching states are typically, activity that takes place in space is typically attributed to the launching state. And so that would present some attribution issues, answer some questions, perhaps raise others, where even if you were having an entity that is in space, say a commercial satellite entity, that is engaging in some sort of unlawful activity, that might still be attributed to a state if that state is the launching state.
Great, thank you both. Mr. Hoverston, one of our guests today wants to know about the proposed prevention of an arms race in space treaty. Is that likely to have an impact on where we are today, or is this just lip service to try and make it look like we're doing something about the concerns that have been raised?
No, those discussions are very real. So the prevention of arms race in outer space, or PAROS, is a separate effort that's akin to the PPWT treaty that I mentioned. Again, it's been the United States that has opposed those efforts primarily for definitional reasons, verification reasons. And one thing I didn't mention is that the PPWT treaty, while it would prohibit weapons in outer space, it does not address at least direct ascent satellite weapons, or ASATs. And those are the capabilities that we believe multiple states, China and Russia in particular, are developing. So it's not lip service. The problem is, and this isn't just in in international space law, it's a broader issue in international law and relations in general, is that bringing nations together on a multilateral level, dozens of nations to sign on to these large arms control or law of armed conflict treaties is proving increasingly difficult. States don't want to sign up to these broad legal restrictions. There's been a movement away from legally binding treaties to non-legally binding agreements, and in outer space, at least, we can talk about what started as a European Union effort on space norms. It was going to be a non-legally binding instrument. It eventually came out of the EU and the broader international community, but states couldn't even agree to sign up to non-legally binding terms regarding space, and there's some very specific and complex reasons for that. So I don't think it's lip service. I think it will continue to be discussed, but I think the likelihood of any kind of broad instrument coming, being negotiated and coming into effect is unlikely unless there's unfortunately some kind of catastrophic event in outer space.
Okay. One of our guests asks, if a commercial organization, i.e. SpaceX or someone else in space, has a breach, should they be looking to the government to help them with countermeasures? Or should the government's expectation be that commercial organizations essentially employ their own countermeasures against either state or non-state actors that are jamming or using attacks on their satellites? For any of our panelists who want to weigh in.
So this, Mike, I'd say it depends. If the activity is happening in space or the effect is being delivered from a space object, there is, under the Outer Space Treaty, state responsibility. In other words, states are responsible for the actions of its corporate entities and individuals. If, however, it's just some kind of jamming from the ground, like Dr. Whedon was discussing, there might be other legal manners to hold those states responsible. And certainly commercial entities, there are, and I'll let Dr. Whedon address this, but there are practical ways that they can try to avoid the jamming. I think corporate entities would need to be careful if they were actually looking at taking some type of offensive or affirmative action to stop it. That would get into some legal questions that, frankly, I haven't considered in detail, but would be interesting. I'll open it up to the other panelists if they have any comments.
Yeah, this is Brian. And this is a really good question in the sense that it is something that's being kind of actively discussed between companies and also with governments. As I kind of hinted at in my discussion, the U.S. government uses military government satellites, but also commercial satellites for a wide range of activities. During the height of Afghanistan and Iraq, something on the order of 85% of the U.S. military's broadband satellite communication needs were carried over commercial satellites, not U.S. military satellites. So I think there's probably a difference between the case where the government is purchasing a commercial satellite service, and then that satellite service comes under some sort of interference or attack, versus a case where it's just a commercial satellite is doing something not related to the government, and it comes under interference or attack. I think those are probably going to be two very different answers to that question. And honestly, I don't think anybody really knows what the answer is going to be. As Michael pointed out, ostensibly governments are responsible for their behaviors in space, but there's not a whole lot of case law and precedent kind of tangling what exactly that means and what the requirements are and sort of means of kind of influencing that behavior.
This is Ross, and I'll jump in just to mention briefly that it is also interesting that the cyber law community is really discussing that same issue, and there are discussions and proposals regarding whether private actors should be able to conduct counter hacking, essentially, if they come under attack. Whether they should be allowed to do that, to what extent they should be allowed to do that. So in a sense, you have these two legal entities, legal regimes, I suppose, looking at this issue at the same time in parallel with each other, with some differences in how it's applied, but with similar issues. And so it may end up being that kind of a legal consensus springs from the cyber discussion and ends up finding its way over into the space community as well.
Great, thank you all. Panelists, this will be our last question, and it'll be a quick one. One of our guests asked about the Little Book of Space Law. More importantly, if you had to recommend just one or two resources for our viewers today to go out and find out more about your areas of expertise, what would you recommend that they turn to? It could be a book, a magazine, a professional resource. What's the best thing to go to next?
This is Mike. There are some texts out there on space law, some treatises, if you will. I won't name any specifically just for an endorsement purpose, but there are some texts out there. In the coming years, there's a project, an international project, working on a manual on international law applicable to military uses of outer space. Assuming that project is successful, there should be a comprehensive manual coming out, but that's probably a couple years down the road. And then for official texts and discussions, there are United Nations Committee on the Peaceful Uses of Outer Space, UN, USA. There's some UN sites that are good resources.
This is Brian.
This is Rob. Oh, I'm sorry. Go ahead. Go ahead.
So on the orbital mechanics and physics side, there's a great resource out there put out by the Union of Concerned Scientists called The Physics of Space Security. It's a freely downloadable PDF, and it has just good background on all the things we've been talking about today, of kind of how they work in the real world and the pros and cons of them from a military perspective. And that includes things like co-orbital and kinetic and other kinds of kinetic weapons, direct energy weapons, interference, and others. So that's a pretty good resource to get more information about that.
This is Ross, and I'll second the suggestion of the Malamos manual that is in works. It will not be summer beach time reading. It will be very law heavy, similar to say the Tallinn manual regarding cyber law, if you're familiar with that. But that is currently being developed, and that will be very informative. Certainly, it won't be binding on anyone, but it will be a good discussion of experts' opinions. And then also, if you're looking at something to just watch, I'll do a brief suggestion, I guess, because it involved the Joint Space Operations Center, which is what I work at. CNN has a special on, and I forget what it's called exactly, the Star Wars Battle in the Next Frontier, something along those lines. And it discusses a lot of the things that we've been discussing today, gives some technological background, some geopolitical background, and some legal background as well. So that'd be interesting to watch.
And 60 Minutes has a similar special. It's a few years old now. It's called the Battle Above, but it's interesting, and it has General John Raymond, the commander of Air Force Space Command, and General John Hyten, the commander of United States Strategic Commander, are both in that program, as is the Secretary of the Air Force.
Great.
And
unfortunately, that is unfortunately, that is all the time we have today for questions. Thank you, everybody, for joining us. It's been a great day. Take care, and we'll look forward to seeing you next time.